Action. All right, looks like we're live. Welcome, everybody, to the second episode of the Accessible Web Podcast. We're here today, George and I, with Dan Goldstein. Dan was gracious enough to join us. We've had a previous conversation with him with our Accessible Web team, and really he was part of what spurred on this idea to have a podcast. We had such a great initial discussion that we figured, man, we should really talk to other people that have been in this web accessibility space, but really the broader accessibility space, because accessible web, I'd call us still a startup. We have a lot to learn. We're really focused on making sure we're doing this right. And so just understanding kind of the people, the motivation behind disability law in this country is really important. So Dan Goldstein was an attorney with the Baltimore law firm of Brown, Goldstein, and Levy until 2017. Dan became involved in the field of disability rights law nearly 35 years ago at the behest of the National Federation of the Blind. Beginning in 2000, Dan concentrated on accessibility of digital content and devices, including ATMs, voting machines, accessible absentee ballots, websites, e-readers, kiosks, educational software, and instructional technology, amongst others. So thanks for joining us today, Dan. It's awesome to have you here.
It's my pleasure.
So I guess, aside from our my brief bio, tell us a little bit about yourself and how you got involved, how you found yourself in this space.
Well, I started representing the National Federation of Blind in 1986. And near the end of 1999, the president of the NFB, Mark Maurer, had become concerned with the fact that we were seeing more and more digital devices and digital content in the world, which he thought should be good news for the blind because it's zeros and ones. It's not inherently visual, audible, or tactile, but can be any one of those three. And he said to me, if I buy a new house today, I will lose a lot of my independence. And I said, what are you talking about? He said, well, in my old house, the thermostat has a dial. In a new house, it'll have up and down arrows with a digital display. I won't be able to set my own temperature. My stove and my washer and my dryer in my house have dials. But if I buy new appliances, they'll have up and down arrows and digital displays. I won't be able to cook my own food or do my own laundry. I want you to do something about that. A task I never completed. But I said, well, where do you want me to start, sir? And he said, well, why don't you sue Microsoft? I took a deep breath and said, well, for starters, just for practice, could I start a little bit smaller? Fine, sue AOL. So we filed the first web suit ever on accessibility against AOL at the beginning of 2000. And then we've been off to the races ever since.
Interesting. It's really interesting. We all often think about how powerful, I guess, digitized text is and how powerful technology is when implemented correctly to make things accessible. So I just remember that first chat with you that we had, and I had never considered the barriers that a lot of these digital technologies could introduce. In a lot of what we're doing, we often say to clients, of all the places, the web should be the place that is most accessible. It doesn't have the barriers of the physical world, but is really interesting to just get that perspective that in some circumstances the physical world there, that tactile, the ability to use the other senses that may not be your sense of sight if that's where you have a disability, it doesn't exist unless things are done properly. So that was pretty eye-opening for me when you first mentioned it.
Well, the fact is that the digital world is still overwhelmingly inaccessible. WebAIM has now, I think, 2 years in a row, done an automated study of the 1 million most popular websites in the world, just the home pages. And the first year, I think it found 98.75% of those home pages had 60 or more accessibility barriers. And I think the next year, the number had gone up. And there are areas that, in many respects, I think are more serious than the web, harder to attack legally, and that is software. And all too often, software is inaccessible. If you're a blind person today and you work for any healthcare organization, be it hospital, doctor's office, as a transcriptionist, as a psychologist, whatever it may be, chances are that your employer uses Epic software. In which case, chances are you can't do your job. Google, when it designed Android, didn't think about accessibility. And it took them from 2004, quite some time, I think at least 6 years, to make Android accessible. And the same thing for Google Docs, except it took them even longer to make that accessible. But the ADA doesn't let you sue a company that makes inaccessible software.
So let's get back to, where'd you go from Microsoft? Did you have any success in suing Microsoft? What?
No, it was AOL that we sued.
AOL, okay.
Yeah, we sued AOL, and then we negotiated with settlements with a number of companies. Amazon was a big one. And as we started negotiating with various companies, we learned an important lesson, which is that while it's not hard to have an accessible website, companies don't know how to maintain an accessible website. And when I started settlements with companies like Amazon and eBay and so on, I would say, look, you know how to run your business. We don't know how to run your business. Let us tell you the goal line. Go ask your developers how long it will take them to get there. Multiply by 2 because all developers are optimists. Come back and say, this is how long we need, and we'll write down the agreement. And that turned out to be a very foolish way to do this, because the company didn't understand that it needed infrastructure changes. It needed to train whoever codes to the website on how to be accessible. It needs to institute testing. It needs to make accessibility part of job descriptions and part of job reviews. There has to be somebody at the C-level who knows what's going on and whether there's success or not success. So we had, after our initial round of lawsuits and settlements, we had to change our approach. And one of the companies that we sued, Target, is today, I think, an extraordinary embodiment of culture change and infrastructure change. On everything from their website to how they develop native apps, I think they've got it right. But that really is a critical factor. You can't just say YCAG 2.1 or AA or whatever is the standard du jour. You've got to help the company understand what it needs to change internally.
So, Dan, would you agree that it takes more than just bulletproof using Peter's term from a question, bulletproof WCAG guidelines or just as much effort in user interface testing?
Oh, testing is absolutely critical. I remember we had at one of our meetings with Amazon, Ann Taylor, who was then at the National Federation of Blind. She's now at Microsoft. Ann is a blind woman, and she was in a room with 40 Amazon employees, each of whom had a console in front of them. And she said, well, the first thing we're going to do is turn off the screens. And then we're going to look at the website. Everybody panicked. How are we going to tell anything about the website if we can't look at it? And so you need users who, that's how they do things. They use the computer without looking at it.
Yeah, that's a really important point. Along that line of thought, if and when WCAG guidelines get folded into ADA, what else is going to be needed to make it more universal? And because we know just because it's law, that's not going to solve anything. What needs to be added to that to make it successful after 30, 40 years?
Well, I wish I knew the answer to that. Because look, I litigated these cases for 17 years, and then at the end of that, WebAIM told me that I had maybe affected 0.025% of the, or 1.25% of the million most popular websites. So obviously litigation is not the answer. Part of it is effectively making the business case.
Yeah.
Having the company understand they are losing business when they are inaccessible. Not just to the blind, because the blind are not the biggest users of screen reader software. The dyslexic community is, and they're huge. And it's not just them, it's folks who can't use their hands, vets who, for whatever reason, no longer can use a mouse and need something else, a voice command. This is now a big part of our population, and it's a growing part of our population. Maybe not the injured vets, but we're outliving our eyes and ears. And diabetes is a big deal in this country and is going to continue to be a big deal in this country. And that means more loss of sight, more loss of being able to feel your fingertips. And so the business case, I think, is very strong. And I'm told by folks like you, I don't have the technical knowledge, that websites that are accessible are also more user-friendly to people without disabilities and don't break as often. So, this is this should be like trying to sell steaks at 2 cents a pound.
We often try to get this across to our customers, on sales calls, and we have the benefit that most of our customers are coming to us with an interest in doing this, so we're not banging on doors trying to convince people that this is the right thing to do. We've created a good brand and I think a good company, and a lot of people are coming to us to help. But one of the big things is, you can't think about this as this expense for those people, that people seem to have in their head that we're just doing this for users that might be blind and using a screen reader, and they look around on Church Street here in Burlington, Vermont, and in a given day you see a handful of people with a cane and glasses, and that's what they think they're designing for, this very small subset. And we really try to get across this is for everybody. We're all just temporarily abled. I like your outlive our ears and eyes. If any one of us lives long enough, we're most certainly going to have some sort of disability. And, it's for, if we design for universal design, and design for everybody, those curb cuts that, help the people with wheelchairs, and were mandated for wheelchairs, they help the UPS guy get packages up on the sidewalk. They help a parent with a stroller. They help everyone. So if we can really implement these best practices, there is 20% of the population that lives with a disability, and most disabilities aren't obvious. Someone with dyslexia, you don't know when you're walking past them on the street, or even having a conversation with them in a restaurant a lot of the time, but they're there. And then, if we really do this right, it's not just those 20%, it's everyone that benefits.
Well, that's right, and it even gives birth to new conveniences for everyone. For example, you two are probably too young to remember when suitcases never had wheels. But they didn't used to have wheels. It was only after the federal government mandated ramps in airports and train stations that all of a sudden we had this new thing. These suitcases, they had a handle that pulled up and they had wheels on the bottom. And it was fabulous. We could also use it walking down the sidewalk from our office, and so on and so forth. That didn't used to exist. And accessibility gave birth to an industry that benefits all of us, whether we have a disability or not. It probably wasn't good for bellhops.
Yeah, I saw a poster this morning. We were looking for artwork for a new space, and the poster said, "If you think the wheel was a good idea, you'll love the ramp." And there were some cartoon characters that really kind of got the message across, especially from the city and stuff.
The idea of accommodations is a very majoritarian idea. What I mean by that is the National Federation of the Blind at its headquarters spends huge amounts of money to accommodate me, you, George, and you, Pete. Because they have lights. And they pay a giant lighting bill. And it doesn't do them any good whatsoever. My former law partner, who's a wheelchair user, accommodates me by having a chair in his office.
Yep. Yeah, fair enough. So let's try to keep focused on some legal stuff while we have you. I know we could talk all day about general accessibility, but I really want to give our listeners the opportunity to hear some of your war stories. So when we're doing when I'm doing sales with a new customer, or I'm doing a webinar on ADA compliance, my timeline of why does your website need to be accessible per the law usually starts with Target. So what was different about Target? What changed in your approach from a legal perspective with Target and moving after Target compared to those earlier cases you mentioned before?
Well, that's an interesting story. And let me start at the end and then work backward. If you have a website and people who live in New England, anywhere in New England, then, or anywhere for also in the Midwest around Chicago, Indiana, etc., you can be sued if your website is not accessible. Because the courts in those jurisdictions have decided that the requirement of accessibility does not require a physical space. And that really shouldn't be an argument, because a travel service that only exists over the phone, where you don't go into the office, that's covered by the ADA. There's no question about it. But in some parts of the country, and California federal courts are part of it there, they think that websites are not covered because they only exist online. And of course, that's not true either. There's a closet somewhere with a bunch of servers, right? And Target is interesting because everyone sees it as this great victory. The fact of the matter is that the suit was started by some very good lawyers in California. If I'd had my druthers, we would have sued Target in Massachusetts. And but I didn't have my druthers. And so Target was actually not a great win. What the judge said in Target was, if the service is associated with the store, the physical stores, like ordering a prescription online from Target that you're going to pick up at the store, or you want to see if something is in that particular store near you, that's covered under the ADA. But if it's something where you go on the website and you order it online and it's delivered to your home and you're never going into the store, that's not covered. And I was astonished when the world saw this as a great victory that was going to help make websites accessible. But in the meantime, every time we brought a case in Vermont, New York, Connecticut, Massachusetts to establish that they needed to fix their website, everybody settled. And it became very difficult to get any case law to support the idea that websites are covered under the ADA. We got a big victory in a lawsuit we brought in Vermont against a website called Scribd or Scribed, I'm not quite sure how to pronounce it, where the judge wrote a fabulous opinion explaining why websites are covered.
So Dan, when you're saying case law, what you're saying is that someone actually needs to fight this in court and get a judge to make the opinion, because all these settlements are just, if it's a settlement, it just goes away and it's over. But
right.
if there's case law, that's like the target is at the beginning of the timeline that I've always learned about, because that was the initial case that set the legal precedent with the judge's decision. Is that correct?
Right. That's correct.
Okay.
And unfortunately, we have gotten this mill of lawyers who do what, for want of a better term, many call drive-by website lawsuits, who file with the intention of settling. And every once in a while, a defendant says, hey, these schmoes aren't prepared. Let's tell them we're not going to settle. Because it's one of the things about websites is it's far cheaper to make it accessible than it is to pay a lawyer to defend the case. I mean, there's no comparison. We never could figure out why Target fought us. Walmart's website was always accessible because they want everybody's business and they don't care whether you're blind or not. And I used to drive the people at Target crazy by saying, well, Walmart can do this. But just to give you an example of the kind of disaster, some folks decided to sue Southwest Airlines in, I think it was Alabama or Mississippi or some very hostile forum for its inaccessible website. Now, they could have won that case without making any law, simply by arguing that that is a service of the physical Southwest Airlines. You're ordering a ticket that you're going to go and use at the airport to get on a Southwest Airlines plane. That, under the most traditional view of the ADA, is covered. They never argued it, and it was another case in the loss column.
So then what were I guess if I follow my my PowerPoint timeline, the next big case was Netflix. So what was it about Netflix that kind of expanded the legal precedent?
Well, first of all, I should explain Netflix was not my case.
Yep.
My contribution to Netflix was recommending a lawyer in Boston as local counsel for the Disability Rights Education and Defense Fund. What was uh, big about Netflix was that, as I had said before, it was clear that the case law should be uh, in the New England, what's called the First Circuit and the Second Circuit, that websites are covered. And the plaintiffs in Netflix were able to get the judge to say that. And I was nervous, to be candid with you, that there was going to be an argument that while Netflix had to be accessible, that didn't apply to its contents. You know, you need to be able to get into a bookstore. It doesn't mean they have to send you Braille books. But happily, that didn't come up. And we get audio captioning and we get closed captioning on these films.
Now, Dan, how does that compare? Because I know, is it Hatha Trust, the case that
Hadi Trust. Yeah.
Hadi Trust? Now, that sounds like a bigger success because I know it means a lot to you. Can you explain that further?
Sure. So at one point, Google decided that it wanted to also have all the knowledge in libraries on Google. And it started negotiating with initially the University of Michigan, but what ultimately became, last I knew, somewhere around 25 university libraries, and there's probably more now, to digitize that work. So we told Google, look, you're going to want to make it accessible. And they said, we're not interested. And that just seemed bizarre to us because if you want to be able to do a search of a book, you have to OCR it. You have to do optical character recognition. And if you OCR it and you add in some metadata that's going to be helpful, like this is a page number, this is a footnote number, this is a chapter number, it's going to be very useful to sighted people. And we ultimately had to start going to universities and saying, really, you're going to make a deal with Google where you're going to get back a digital copy that's not accessible? And, you know, university librarians are all about access to information. And they were appalled. So ultimately, Google said, can we talk? And they created over 15 million accessible digital books. And imagine being blind and all of a sudden all the accumulated lore and knowledge and imagination of the world is available to you without regard to your disability. But the Authors Guild was heavily bent out of shape and said, this is massive copyright violation on a huge scale. And they sued the universities. And so we intervened as the defendant, that is to say, sue us too, the National Federation of Blinds and Blind Scholars. And we said, guess what? Making books accessible is a fair use, just like using a book to do a satire or parody or a book review or whatever is a fair use. And the court said, you're right. And I'm not sure quite of the current status, but a system was being set up so that anyone who's blind whether they're a scholar or not, an adult or child, can access this amazing collection.
A sunrise of knowledge for sure.
Yeah.
Now, how does that fit in? Our first meeting and discussion, you suggested that we should look into the epub standard and accessibility. How does that fit in with education nowadays and the importance of it?
Well, I mean, that's one of the brightest horizons, is that all of the major publishers, who are all members of something called the International Digital Publishing Forum, have agreed to use accessible EPUB 3 in their publications. So that means going forward that the major publishers will be producing books that are accessible as they are published.
That's fantastic. And I'm learning, being involved in that work group with George. Now, you mentioned OCR. That made me quickly think of a software company that we're both very familiar with, Adobe, and how they've come and gone with skirmishes with especially the blind community. How do you view that journey? And you've talked to various people that are involved at Adobe. How would you use that as a model for other companies to follow to get accessible, or they should have done it better? Or because I know just within the last 3 years, 3 or 5, it seems like they've made some ground. So
I think that's a hard question for me to answer because I haven't seen Adobe from the inside. There have always been some people at Adobe, like Andrew Kirkpatrick, who were committed fully to accessibility. My guess is that that 3 or 4 years ago, there was some changing of the guard at the C level, and all of a sudden he had top level support because we've seen huge accessibility changes at Adobe. It's been interesting to watch with Pearson. They've gone from having created a whole bunch of Flash textbooks that were completely inaccessible to starting to make things accessible, to losing almost every accessibility person in the company, to making a giant push now, and from what I'm told, fairly successful push to accessibility. And I think a big part of it is if you don't have the support at the top, you can't do it. Not in the big corporations, anyway.
Yeah, I had the good fortune of backfilling in for accessibility analysts at McGraw-Hill. And that was the biggest difference because it came from the top down. Developers to marketing to senior leadership. It was a corporate culture. It just had to be. Internationally, that was the standard. Canada, they went by their guidelines, UK, et cetera. But it was the first place in my career that, oh, wow, this is how it's done. And I never saw a developer group until Accessible Web that just get it. And it was just really refreshing. And that really kind of pushed me to find out more answers about accessibility. Now, you started as a federal prosecutor. Differences between and similarities between federal prosecutor and a disability lawyer fighting the windmills for accessibility?
Yeah. I started off as Goliath before I became David. At a very young age, I'm standing up to a jury and saying, my name is Daniel Goldstein. I represent the United States of America. That guy over there represents the scumbag. I didn't quite say that, but
Yeah.
that was always the implication. And then all of a sudden, I'm trying to get Apple and Amazon and all sorts of folks to do the right thing. And the training as a prosecutor made me very comfortable with being in the courtroom and crafting legal arguments and organizing the big case. And for me, the big turning point was coming to understand through the NFB that disability rights is part of civil rights, something that's still not widely accepted.
Where would you want to see accessibility law go in the coming years? One of our big things is, when can we finally get the ADA to formally apply to websites instead of these, call them drive-by lawyers, call them trolls, call them extortionists, right? We hear our clients say a lot of things.
Oh, sure.
Because of the way it currently is, and we try to spin it positively because the carrot's better than the stick, I guess. But when we started this business, the seed was kind of planted in 2016-ish. Obama was still president, and we were hoping the ADA would get amended, but that never happened with the previous administration. So, where would you want to see? Where do you predict that accessibility law in the U.S. is going? Do you think it'll get to a point where someone can stand up and represent the U.S. government and be, pushing accessibility onto these businesses?
Well, and I should say, DOJ under Obama was active and joined me in web accessibility lawsuits. H&R Block in particular was a case of the United States of America and the National Federation of the Blind versus H&R Block over the income tax website, being able to use that to do your taxes. The two big changes. I would like to see DOJ issue a regulation that explicitly says that websites are covered. We were 97% of the way there under Obama, and I've been told indirectly that Valerie Jarrett killed it. I don't know if that's true or not, but it went over to OMB from the Department of Justice and never emerged.
What is OMB?
Office of Management and Budget.
Got it.
Even DOJ, if it sets up propose a new regulation, it's got to go through the Office of Management and Budget.
Got it.
The second thing I would really like to see, although it'll slowly put you guys out of business, is I think that those who offer authoring tools for websites should be held liable if those tools do not enable the user to make an accessible website or don't facilitate it. You look at small businesses and they go online. I got to build a website for my new bakery. Oh, okay, here's Wix, here's GoDaddy. They look cheap and easy for a non-technical person like me. And the poor bakery owner doesn't know that they've just made a choice to be inaccessible. And if the authoring tool software folks knew that they were exposed to liability, it would be very hard to put up an image without an alt tag in building the website.
And Dan and I were discussing this yesterday, and I was bringing up that one of the first programs I believe made that a requirement is Dreamweaver, which is Adobe now, but it was under Macromedia, had accessibility tools that you had to turn on. So when you inserted a image, it would prompt you to put in an alt tag, but it wasn't required. And most developers that I taught or ran into weren't even aware. They didn't really publicize it. And that's an interest that I have in why I think community outreach is important to not solve the accessibility, but to make people understand that dyslexic populations are a bigger user of screen readers. And I would venture to say most people aren't aware of screen readers. And we were discussing this morning about some community projects. And I heard this from someone from FEMA. There's a reason why most of us know what to do when our clothes catch on fire: stop, drop, and roll. Why? Because we were taught in school. And my big thing is, why don't we just send a flyer that we're having a presentation of the screen reader, person using a screen reader, that, send it home with a third grader, and guaranteed we'll probably get some feedback from parents or awareness, and kind of get the community more involved of how people use accessibility. Because I'm always amazed that people that aren't aware of it, it's not out of malcontent or I don't care about disability people. It's out of ignorance or not being exposed to it. And we're gradually seeing it in mainstream advertisement. First came, diversity. Now you're seeing more wheelchairs and people with canes, right. But it's going very slowly. And I just think, is there things that we can do in the community that would kind of build this awareness or help get the word out?
That's a great question. Let me just say first that I think there are probably folks who are using screen reader software who don't know that they are. I'm thinking of VoiceOver.
Good idea.
Apple products. Yeah. That was designed entirely as screen reader software, and yet it's used, I think, by many people. I'm not a Mac user, but I think it's used by many people in the population at large. And the iPhone is what you'll see most blind people using because it's so accessible. Android's catching up, kind of. The big issue, the big way to create more of a sense is to somehow help the business community, understand that disabled doesn't mean less able. Mm-hmm. And that's still the biggest barrier. I'm going to be doing this for somebody out of charity because they're inferior to me. That is still the perception of disability in the world, and particularly in this country. And somehow it seems that knowing that Stephen Hawking is smarter than the three of us combined doesn't seem to change that. Or that there are Paralympians who can do absolutely everything athletically 10 times better than we can. It doesn't seem to change it. So changing that social perception, I don't know how that's to be done, but we're not going to get there until that happens.
I think that's the nice thing about, what's happening now with diversity, equity, and inclusion. Kind of, it's, knock on wood, but hopefully it's here to stay. Hopefully the pendulum has swung left and it kind of stays left, because I think that's, it's been just remarkable over the last couple of years to see how many people are coming to us as customers for the right reasons. We structured this business when we were first starting it up, when I first had the idea to do web accessibility. I was thinking, like, let's put a nice positive spin on avoiding lawsuits. But the clients that come to us, and the clients we want to work with, are the ones that are coming to us and they're saying, look, here's the 6 pillars of our company, and one of them is diversity, equity, and inclusion, and we want to make sure our tools are accessible to everybody. And they're generally doing it for the right reason. And so I totally get that. And there's a world where I hope we put ourselves out of business. I say this all the time. Like we look at this a lot is the same as when mobile phones came on the scene, and there was this new technology. And that's not to say web accessibility is new, but it is new to a lot of web developers. It is new to a lot of teams. And there's groups that, companies can choose to use Accessiby or AudioEye or these overlay solutions that put some kind of tools on the screen that don't generally do anything. For users with disabilities, it's a veneer of accessibility, but then there's companies that want to do it right, and they get it, and they're coming to us, and we're finding that there's a huge amount of business out there with those those companies that are oriented properly and that are doing it for the right reason, and that it's not even really about seeing the value, right? Like, the value's good and it should be a secondary goal, but it's about social responsibility and just being a good business owner. So I don't know. Hopefully it's here to stay, and hopefully, I guess we say a lot too, like, we all are holding each other accountable. We see a lot of, we've seen a lot of customers from JP Morgan, right? And I'm a Bernie Sanders guy, right? Like, I don't love big banks and JP Morgan, but it's remarkable how many companies have come to us because JP Morgan is requiring web accessibility in different, RFPs and different projects. JP Morgan is a huge company. They're holding the coin purse in this country in a lot of ways, and when they require it, everybody's running towards it. And we often say, look, this is, if we work with a bank and their online banking isn't accessible, look, hold them accountable. Tell them that we've put up a accessibility statement on our website that says our website is WCAG 2.1 AA conforming, and we've done all this testing. We've done all this testing, and we've made our platform accessible, and now you, the online banking company, should make it accessible as well. So it's an exciting time, and hopefully, I think we can get hopefully the ADA gets amended or changed, whatever the proper term is. And
just needs a new regulation.
Just needs a new regulation, right? And then everyone can kind of get on board with this and have some clarity around it.
Well, Pete, I think one of the hopeful signs is also a capitalist one, and that is that one of your competitors, who I will not name, was acquired by a publicly traded company. And that is a sign that the commercial world is coming to recognize that digital accessibility is here to stay.
Mm-hmm. Absolutely. All right, well, we're kind of at the hour here. Got a few housekeeping things to do. So every podcast episode, we're giving away a Accessible Web t-shirt to one of our followers on Facebook and one of our followers on LinkedIn. So we'd encourage anyone out there listening to follow us on either of those channels and tune in for more posts and more podcasts and more, just general web accessibility content. And of course, get in touch if you want to upgrade your website or web application, or just want to, do a consultation around digital accessibility. But today, our winners, our Facebook winner is Nate Ginsbury. So Nate, if you're listening, get in touch. Otherwise, we will track you down and get you a t-shirt, hell or high water. And then on LinkedIn, our winner is Gabrielle Gabrielle Padriga. So, yeah, thanks for following us, and we'll be in touch to get you both T-shirts.
Benny, they don't give their guests.
Oh, yeah. You'll get a T-shirt too. We just had a fresh run printed. It was supposed to come in your podcast kit, but it didn't quite arrive on time.
You're at the top of the list, Dan.
Yeah. You were last episode was our pilot where George and I just talked to each other. And had
no problem doing it.
And then this was our first podcast with a real guest. So we certainly appreciate you. We appreciate, I guess, first and foremost, all the work you've done in the space. And it blew my mind when you got in touch a few months ago and, mentioned your background in accessibility law. I mean, it literally just blew my mind that I was talking to you. I'm surprised I made it through the call, but on top of that, we appreciate all the work you've done in this space. We appreciate this landmark, law that you've helped create and everything you've done for the disabled community in the U.S. And then I guess secondarily, on a much smaller level, we appreciate you joining us today.
My pleasure.
And I just wanted to say, I've mentioned this to you before, our first meeting together. I was so excited afterwards. I said, we need to do this. And I'm thrilled that you were able to be our inaugural guest. So I think you've started a long line of some good guests we have coming, and just thank you. And
I look forward to hearing those podcasts.
Sounds good.
George, do you know what our next guest is, who our next guest is?
I believe it's Carl Horvath, head of the College Consortium.
Awesome.
Bill Walsh, who you might know, Dan, from formerly of DOJ, Disability Rights Group. He's now with HUD. He's on board, but he has a lot of interesting to talk about that same period. Dan Heller and Kay Chido from DeafLink. Yeah, we have some pretty vocal guests coming, so it should be a good addition. But I think you've raised the bar for all of them, Dan, and also thank your wife for letting you use her log on.
Okay.
All right.
Bye-bye.
Thanks, all. Talk soon.